When a person assumes a risk, the defendant's duty to him is removed because the person abandons the right to complain about his injuries if an accident occurs. There are few circumstances in which jumping out of a moving vehicle is a good idea. In Goepfert versus Filler, we'll explore whether it's so obvious that a person assumes the risk of injury in this circumstance that it can be decided as a matter of law. Chris Stethem drove Michael Goepfert and some other friends to a bar in downtown Brookings to celebrate South Dakota University's homecoming. As Stethem slowed to 10 to 15 miles per hour while approaching a red traffic light, several of the passengers requested to be dropped off in front of the bar rather than walk from wherever Stethem found parking. Stethem told his friends that they could get out if they wanted, but didn't stop the car. The light turned green and Stethem started to accelerate. At that time, Goepfert opened the front passenger door and jumped out of the car. Goepfert flipped backwards and hit his head, knocking himself out. Goepfert was taken by ambulance to the hospital and was released that night. Friends watched Goepfert through the night and returned him to the hospital when he became unresponsive. Hospital staff then discovered a skull fracture and intracranial hemorrhaging. Goepfert died the next day. Alleging negligence, Goepfert's parents sued Stethem for wrongful death and Dr. Elliot Filler for malpractice in a South Dakota circuit court. Claiming that Goepfert assumed the risk of jumping out of a moving car and negated any duty Stethem owed Goepfert, Stethem moved for summary judgment. The circuit court granted Stethem's motion, and Goepfert appealed the issue of assumption of risk to the South Dakota Supreme Court.